Bonjour, bonsoir, good afternoon, good morning, where you are. Welcome. My name is Eric Stasik. I am an SEP licensing consultant located in Stockholm, Sweden. And we are here today to present our second of three podcasts on the aspects of French law and FRAND. And I'll ask my guest today, Cyrille Amar, to introduce himself.
Hello, everyone. Thank you for joining us for this episode 2. I'm an attorney at law in Paris, an avocat. I'm also the founder of a platform, FRAND Avenue, who is an innovative marketplace for FRAND licenses and standards. I've spent quite a lot of time in my career dealing with essential patents and FRAND license agreements, FRAND litigations as well. So today we are going to dive a bit deeper into the duties of the parties which arise out of this FRAND undertaking, which we have shown last, in the episode 1, that it was a FRAND agreement. So we have explained that under the HC-IPR policy, which is subject to French law, the licensor and the implementer are bound by what we call a FRAND agreement. We have explained that this agreement arises out of a stipulation pour autrui, which is just a way of forming the contract. We have explained that the primary obligation under this agreement is for the parties to negotiate in good faith the contemplated patent license agreement covering the patents for which have been declared essential by their owner. Now, we have briefly explained as well what were the respective duties for each of the parties in this agreement. I've tried to summarize them here. Basically, the parties, both parties, have a disclosure obligation. This is because under the French Civil Code, the parties must disclose to each other all information that they possess and that has a direct and necessary connection with the content of the contract, other than the price structure. But it's important. And so what information is it for the licensor? This is precisely all information related to the license portfolio. For example, that's the content of the portfolio, the list of the patents, but not only. It's also the reasons why the licensor declared those patents as being essential or potentially essential to a specific standard. And on the implementer's side, the information which must be disclosed, shared with the other party, is everything related to the implementing products, technologies, territories, sales, all information which is necessary for the other party to make a FRAND offer and eventually reach an agreement on a FRAND deal. Then the next obligation is to negotiate diligently. I mean, this is well settled under French case law. And that has been underlined by the European Court of Justice in the well-known Huawei ZT decision. That's something which is important. The third obligation is a covenant not to sue. You could call it also a right to practice the patents pending the outcome of the negotiation. And that is, of course, the most essential obligation under this FRAND agreement. And that has been well practiced, observed by the market players since this HCIPR policy has been adopted in 1991. And that has been confirmed by the ECJ in the Huawei decision as well. Fourth obligation, which is the immediate consequence of the preceding one, is the right for the licensor to be compensated. Naturally, the licensee or the implementer must compensate the licensor for the use of its patents during the negotiation period.
Right.
And the judge is competent to award damages in the event the parties do not reach an agreement. So for the past use, and I would underline the fact that if the parties negotiate for a long period of time, then they should stipulate at the beginning of their negotiation whether they are willing to waive their right to the statute of limitation or not. And that's important, especially in light of the recent decision in Lenovo versus Interdigital, where Justice Arnold decided that the statute of limitation would not apply. Finally, there is a direct right to the performance of the contract, which is a right belonging to the two contracting parties. So both the licensor and the implementer can seek, can demand the performance of this FRAND agreement before a judge to enjoin the other party to behave in accordance with the obligations that I have just underlined. So that's a quick reminder of what we have seen in episode 1.
Okay, if we go to the disclosure obligations, we kind of touch on the European Commission's proposed regulation. Mandates a register of declared SEPs to be maintained by the EU IPO with various levels of essentiality checks, some random checks, some up to 50, some it's voluntary checks, but different levels of essentiality checks. What is your view of this proposal from the European Commission in light of the information obligations under French law that you just described?
Well, certainly the registrar that is contemplated, the competence center, would facilitate the performance of some of the duties which I have described. I have tried to summarize some of the key points in the EU proposal: the SEP registrar, the essentiality checks, and the mandatory conciliation. I have tried to imagine what would be the impact on the FRAND agreement. Of course, many things remain to be seen, because that will be depending upon how the proposed regulation will evolve through the legislative process. I think that what we can say for the SEP registrar is that it should, in principle, facilitate the disclosure of mandatory information by the licensor. Although today the number of SEP databases exist already, some provide a free access to that information. That's the ETSI database or the FRAND Avenue database for raw data.
Right.
Others will provide a paying access to that information, IPlytics, Patently, FRAND Avenue for additional levels of information. So that information, in fact, is already available. The EU proposal does not, however, in my view, solve the important issue of the lack of transparency related to the implementation and related to the products. That needs to be improved. Databases exist with FRAND Avenue on this respect. I have not seen in the EU proposal any suggestion that this, the transparency should be improved in this respect. Finally, I have noticed in the EU proposal that there's a right or possibility for the patent owners to remove their SEPs from the registrar That seems to me contrary to the irrevocable undertaking under the CIPR policy. So that we need to figure out how this could be conciliated with the existing agreements. With respect to the essentiality checks, again, there are pros and cons. There would be a positive impact if these essentiality assessments provided enough comparison data points, which would cover all possible combinations of TS, technical specifications versus implementation. That remains to be seen. I have not seen anything suggesting it in the EU proposal, but that, of course, could be completed, in due time. The negative impact that I see is in my view, this process could slow down the negotiation and add additional delays to the expected outcome.
Yeah. Okay. Okay. As we discussed in the first podcast, the German courts looked to Huawei ZTE when considering the grant of an injunction, and the result has been a focus largely on the behavior of the implementer and whether or not the implementer would be considered as a willing licensee and not engaged in tactics of delay, in the language of the CJEU. The BGH softened that a little bit in the second CISFEL hire case. It took into consideration a little bit more of the obligations of the SEP holder. But in a contract law scenario, the focus is on the behavior of the licensor, specifically whether or not the SEP holder has made a FRAND offer. And what other obligations fall on the licensor to fully comply with obligations under French law?
Yeah, well, in my view, the German courts have not drawn the consequences of the general obligation to negotiate in good faith, which I have already described.
Right.
Clearly not. In particular, the court should focus, in my view, on objective criteria in order to determine, whether the licensor complied with its FRAND obligations or not. And the test is pretty simple. 3 questions could be put, and the court could answer the following 3 questions. First, has the licensor disclosed enough information about its portfolio? How many claim charts were made available? How many comparable license agreements were offered for consultation? The second set of questions is, has the licensor granted the implementer enough time to analyze the disclosed information? Sometimes it's loads of information. The third question is, has the licensor given a sufficient prior notice before seeking termination of the agreement or jumping, to the gun, seeking an injunction? So these questions are, in my view, much less complex than the direct assessment of the content of the FRAND offer, which gives rise to a debate and complex debate between the parties, and that the court should examine only if both parties are found to have acted in accordance with their respective obligations.
Okay, well, let's turn to the implementer now. What steps should the implementer take in order to secure an agreement with the licensor?
Well, there are two things that the implementer should take. First, I should mention that the implementer should make clear in writing that he is willing to be bound by the FRAND agreement and that he's willing to negotiate. So that's a very important aspect. Because under French law, these license agreement or covenant not to sue would have to be in writing. Next, if an implementer is found in breach of its obligations under the FRAND agreement, then the court will deny its claims to enforce its rights under the FRAND agreement. So implementers and licensors are, in this respect, in a symmetrical position.
Right.
With a major difference, however, because if the implementer is found to be in breach and the licensor is found to have complied with its own obligations, then the court may terminate the agreement and the licensor will then be entitled to seek an injunction in any country. So the draft regulation, by the way, imagined by the EU Commission, is silent on that point.
Yes. Yeah.
And concerning the damages owed to the licensor for the past use, the court may then increase them in order to take into account the prejudice caused by the implementer to the licensor arising out of the breach of the FRAND agreement by the implementer. So that has very important consequences.
Okay. If the licensor and the implementer are not in breach, but they still can't agree on FRAND terms, what remedies would be then available to them under French law?
Well, then there are various scenarios. If the two parties ask the court to set forth a rate, then the difficult question of on which legal basis would the court be based to, how could it replace the parties in determining an essential element of their consent to a contract? That question would be settled. That would be fine. Because absent a joint request, the courts usually, that's the case in France, but also in a number of other countries, the courts are reluctant to interfere in the free determination of contractual conditions. Now, if one party only, either the licensor or the implementer, is asking the court to set forth the FRAND rate, then the court may wonder about the limits of its jurisdiction under French law. And this is where the breach of contract approach is decisive, because the claimant can always ask the judge to settle damages. And of course, the FRAND rate would form the basis of the calculation of the damages sought for the alleged breach of contract. And the judge would have no difficulty to rule in this matter. So once the contract is terminated and the damages are decided, the judge regains his freedom to pronounce a prohibition measure based on patent law. And such a prohibition measure can be subject to suspensive or resolutive conditions, a bit like the Mr. Justice Pierce did in the Unwed Planet case.
All right. Okay.
So I have tried to summarize what I've just said in this chart. We will make this chart available for the participants to this podcast, and you have here sort of a summary of the various scenarios where the licensor, the licensee, or both parties are found in breach, or neither party, because that could also happen, of course. And what would be the consequences? I think it's now time for questions. Maybe you have questions, Eric.
I don't have any further questions for you today, Cyrille.
Okay.
I don't see anything showing up in the chat.
No, well, we are probably too clear.
Yeah.
But I mean, to try to summarize this issue, it's my belief that really the consequences of this very simple agreement, which arises out of the ETSI undertaking, these consequences have not been drawn and properly used in court or in the framework of the licensing discussions. Many disputes could have been solved using this simple analysis, this simple approach. Whether the courts in the future will do it, that remains to be seen. One of the main questions today is whether the Unified Patent Court will accept to deal with this matter on a contract basis, on a contract law basis.
Right.
In my view, the court will have no choice but to examine and decide whether under the FRAND agreement the parties have behaved in accordance with their obligations. I don't think that the parties could ask the court to do that other than by way of a, as a defense. But in my view, the Unified Patent Court could deal with that, at least to answer the defenses of the defendant.
Well, they're going to have to find some way.
Yeah, I have an.
Yeah.
Oh well, I have a comment by Wim who says that Dutch law is very similar. No surprise, but the big question is, why has this argument not been made before?
Well, it has been made before. I mean, I when we started this off, Cyrille, I had a quote that I pulled from Sir Robin Jacobs. I attended one of these telecoms and IP and telecoms conferences in London in 2014, and he gave a legal analysis of FRAND. This is in 2014, and he handed out copies of it. And in it, he wrote, "It doesn't matter whether the defendant is a willing licensee. That is an amorphous concept. It does not matter if he says he is willing to negotiate. For all that matters is whether or not the patentee has made a FRAND offer." And then he went on to emphasize in conclusion that all of this works as a matter of law without the need of any competition law to intervene. So, I mean, the idea that contract law has provided a solution to this has been on the table for a decade. But I think that the competition law defenses and the CJU ruling has really taken all the momentum away from this. But now that we've got courts making FRAND determinations, I think it's unavoidable that they leave the competition law analysis and start looking at contractual law. And then there's no dispute that French law is the governing law of FRAND.
That's what I believe as well. So I hope we will see decisions taking this approach. If there's no other question, I would kindly invite everyone to follow the third and final episode of this podcast, where we will take you for a walk on the FRAND side, as we say, and see how FRAND Avenue can help the market players complying with their obligation and, of course, achieving their goals in an efficient and way, and probably faster and less expensive way. So thank you very much to everyone for attending this podcast. I'm wishing you very good weekends for those who will not work tomorrow, and
that's me.
and that's me as well.
Yeah.
And so we will resume our discussion on this topic on May the 31st. Thank you.
I look forward to it. Thank you, Cyrille. Thank you, everybody. Cheers.